So I would like to introduce everyone to Lone Huynh, who's an attorney with Fredrikson and Byron. She chairs Fredrikson's immigration group and also leads its I-9 audit and corporate immigration compliance and its H-2 temporary workers practice area. She focuses on employment-based immigration, corporate immigration compliance, and global mobility solutions for employers. Lone is a frequent speaker at national conferences and has written extensively on immigration issues and has received extensive recognition for her work, including selection for Best Lawyers in America for Immigration Law in 2020, continuing through 2026. So she's well versed in a topic that many of us want and need to understand more. So without any more talking or further ado, I am pleased to turn the conversation over to Lone.
Thank you so much, Holly. I'm going to share my screen here. As Holly mentioned, I chair the immigration group at Fredrikson and Byron. My name is Lon Huynh, and I know there are many individuals still joining us, but we have so much information today, so I'm going to go ahead and proceed. Holly and I discussed that if there are questions, please feel free to put it in the chat, and then I believe Holly is going to monitor the questions. And so, I'm here to discuss I-9 compliance essentials, how you stay compliant and be prepared for worksite enforcement. We'll also talk about how employers and employees can protect themselves in light of the I-9 audits and increase in immigration enforcement too. So let's get started. We're going to start first and look at the immigration trends. Basically, the immigration enforcement trends that we are seeing and the relevant agencies involved with immigration enforcement, including I-9 enforcement or I-9 audits. See here. I'm then going to discuss best practices for I-9s. I'll go through the I-9 process and then wrap it up with talking about how do we prepare for I-9 audits and immigration enforcement. So immigration enforcement and the relevant agencies, as you know, they're since last year of January, the current administration announced more than 100 executive orders related to immigration. Most of it focused on immigration enforcement priorities of the current administration. So I know that we have heard a lot about different agencies, and what I want to do is go over those different agencies with you. The federal immigration agencies that are involved, we have the Department of Homeland Security, which oversees immigration and customs enforcement, USCIS, Immigration and Citizenship and Immigration Services, and then also U.S. Customs and Border Protection, what we call CBP. So these three agencies have very distinctive roles in regards to what they do for the Department of Homeland Security. And recently, we've heard a lot about the border czar, border what was the title of one of them? I think it was Chief Border Officer, which is really unusual because really for immigration purposes, it is USCIS who is responsible for providing the services and benefits that individuals apply for in terms of immigration benefits. It is ICE, Immigration and Customs Enforcement, who is really responsible or tasked with the interior investigations and enforcement of immigration laws, including smuggling issues, document fraud, immigration raids. It's really Immigration and Customs Enforcement, which is the entity responsible for those enforcement actions. And Customs and Border Patrol, which is CBP, is really only responsible for inspections at port of entries, custom functions, border patrol functions. So any enforcement activities that takes place at the port of entry or at airports. So what has changed though in the last year is that as part of the current administration, the executive orders that President Trump issued stated that one of its priority is controlling our borders, and it essentially gave CBP the authority to also participate in immigration enforcement activities within the interior of the US, which was really only for ICE. And so that's why we see CBP and ICE now being part of the enforcement activities related to immigration enforcement within the US. So what we're seeing now in terms of immigration enforcement trends is based on those executive orders that were issued in the first 100 days of the current administration, and really a continuation of the first Trump administration in regards to its policy. So worksite raids, for example, under the first Trump administration, we saw about 1,800 arrests from worksite raids, a huge increase in I-9 audits, and we're seeing it now. We are seeing, as part of the immigration enforcement efforts, a huge increase in I-9 audits, and also not so much, I would say, worksite raids that have been published, but what we have seen recently, for example, I'm in the Twin Cities here, is that ICE will come with the I-9 audits, and for whatever factors it uses, some of those entities who have been targeted for I-9 audits may face worksite raids a couple of days later. And so that's a trend that we're seeing in regards to how it plays out with each other. Currently, employers who face I-9 fines, if you have paperwork violations and you're facing I-9 fines for the first time, the fines can range from $288 to $2,861. For individuals or employers who the Immigration Service determines has engaged in knowingly employing unauthorized workers. So there has to be knowledge involved here. The fines can range from $716 to $5,724 per violation. So I'm just kind of giving you a sense of where we are in terms of I-9 fines, and I'll focus on the Form I-9 now. So best practices for compliance. As you may know, the Immigration and Reform Control Act prohibits employers from hiring individuals who are not authorized to work. So failure in complying with IRCA can result in civil or criminal penalties, what I showed you, what I shared with you previously. The purpose of the I-9 form is to establish the identity and employment authorization for any new hires after November 6, 1986. So any employers, if you are currently employing employees, you have to fill out I-9 forms for individuals that you hired after November 6, 1986. Those hired before, you are not required to have a Form I-9 on file. I'm going to share with you some I-9 resources. I have to share with you that USCIS has great resources for the I-9 form and how to complete them. So this is the link to the website. There's a handbook for employers. I reference it all the time. I've been practicing for more than 30 years in immigration and I-9 compliance, and I still look at the handbook for employers because it's updated also with all the changes that are happening. USCIS does provide updates on how to complete the Form I-9, so I recommend you take a look at it. And I-9 Central website is where you'll find all of this information. As I mentioned, the I-9 requirements are employers have to have an I-9 on file for any employees hired after November 6, 1986. I always say it's never too late to fill out a Form I-9. And so if you find that you don't have an I-9 on file for someone that you are required to, you can take the steps to remedy that and ask them to complete a Form I-9. When can employers ask employees to fill out the Form I-9? The rule is that you can only or you should only ask an employee to fill out a Form I-9 after the employee accepts the offer of employment. The Form I-9 itself, which I'm going to go into detail, has a Section 1, and the employee is responsible for filling out that form, Section 1. The employer is responsible for Section 2, and there are supplemental forms that are attached to the I-9 that, for example, for re-verification, it is the employer who has to fill that out. Now, if you have employees who don't speak English or need translation to understand or interpretation, you can have someone be a translator or an interpreter to help them fill out the Form I-9. And there is a document that they have to fill out, the Supplement A. So there could be a translator or interpreter who helps an individual fill out that Form I-9 if they don't speak English. Okay. So this is how the Form I-9 looks. I talked about Section 1, which the employee can only fill out this section unless you have a interpreter or a translator help them. Section 2, the employer or its authorized representative must complete Section 2. So the first section is regarding establishing who is this individual that you're hiring, and that is why the employee is responsible for filling that out. Along with that Form I-9 that you see here is a list of acceptable documents that we recommend that you give your employees, whether it's electronically or a physical copy, depending on what your I-9 system process is. You want to make sure that they have a copy of this document. You as an employer should never tell them what documents they should submit. Only they can decide what documents they submit or present to you in order to fill out the Form I-9. So giving them this document really protects you too, because no one can allege that you told someone specifically what documents they needed to present to you. So this is the list A of acceptable documents. This is on that list of acceptable documents, and documents under list A establish employment eligibility and identity. Okay, so any of the list A documents will establish both identity and employment authorization. Again, as an employer, you are not required to make copies of the supporting documents that your employee presents to you. My advice, and I know that there are differing legal advice from various attorneys on this, in my years of practice in representing employers in I-9 audits, I have found that if you have copies of supporting documents, even if you make mistakes, and everyone makes mistakes on completing the Form I-9, if you have those supporting documents, you can make corrections using those supporting documents and avoid potential fines. So this here is a list of acceptable A documents. I'm not going to go into detail and read all of them for you, but U.S. passport is the most popular. The I-551 lawful permanent resident card, which is what we usually call the green card, is an acceptable document. Know that any of these documents right here that you see, if your employee presents these documents, you do not need to conduct re-verification if they expire. And the reason, the only document you would need to do re-verification is the employment authorization document card here. But for a lot of employers, they get confused because the green card has an expiration date. You do not need to re-verify the green card, but you do need to re-verify the employment authorization document if it's presented to you to establish their employment eligibility and identity. So these are examples of some list A acceptable documents that you see here. You see here a copy of the visa from a passport, also the employment authorization card here, along with I-94 records that are presented along with the copy of the foreign passport that could be a combination that you also see for the List A documents. All right, let's look at the List B documents that are acceptable. These documents only establish identity. So for example, driver's license or identification card, ID cards issued by the federal, state, or local government. The List B document only establish the individual's identity, okay? In addition to the List B document, if someone is presenting to you a List B document as part of the I-9 process, they also need to present to you there's List C document here. The List C documents establish employment eligibility. So when someone presents a List B document, they also have to present a List C document, okay? List C documents that establish employment eligibility includes the U.S. Social Security card. The Social Security card should not have any restrictions listed on it. So you may get a Social Security card that states work authorization only. That Social Security card is not an acceptable List C document, okay? And so these are other examples of List C documents. I'm going to go here. The Form I-94 departure record is a List C document that establishes employment eligibility, certificate of naturalization. These are examples of List C documents that are authorized by the Department of Homeland Security for work authorization. So the Form I-9 Section 1, the first section, as I mentioned, the employee has to fill out the information, a lot of biographical information. If they don't have the requested information, they need to note that they don't have that information. A question that we get asked is the Social Security number required? It is only required if you are also an E-Verify user. The E-Verify system is a web-based system that an employer uses in addition to the Form I-9 process to confirm the information that an employee has presented on the Form I-9. It is a voluntary service, or you can sign up to use E-Verify on a voluntary basis. It's not mandatory unless you are a federal contractor and part of your federal contract requires it, or you're in some kind of local jurisdiction or state jurisdiction that requires it. So in situations where you are an E-Verify user and someone doesn't have a Social Security number, you would note that they don't have a Social Security number and come back to the E-Verify form to complete it once they get their Social Security number to you. So someone not having a Social Security number by itself doesn't mean that they're not authorized to work, and you can continue with it. I talked earlier about the Preparer and Translator certification form. If you're using a translator or interpreter to help your employee fill out Section 1, the translator or interpreter needs to fill out this section here. Okay. All right, let's talk about Form I-9 re-verification and rehires, which is the Supplement B. If you have a Form I-9 where an individual has presented work authorization that will expire, you as an employer are required to docket to follow up with them before that expiration date and ask them to present new documentation to re-verify their work eligibility. You're not re-verifying their identity. It is their work eligibility that you're re-verifying. And so Supplement B is the document where you would complete as the employer any new documentation to establish their employment eligibility in the United States, because their original document establishing employment eligibility has expired. Okay, when is it required? Supplement B, in situations when you have to re-verify, as I shared, when employment authorization has expired and you need to conduct re-verification, when they are hired within 3 years of I-9 completion. That's when you have to, it should say complication, 3 years of completing the original I-9s. If they are rehired within 3 years and you have their I-9 on file, that's when you complete Supplement B. If they have a legal name change, that is when you also complete the Form I-9 too, or the re-verification section. I'm going to next talk about what happens during an I-9 inspection. We do know that ICE has been issuing a lot of notice of inspections to employers throughout the U.S. I can share with you as part of Metro Surge here in the Twin Cities. Part of it included a slew of I-9 audits that were issued against employers throughout the state. And right now, what you see in front of you is the anatomy of an I-9 inspection. What happens? An employer, if you're targeted for an I-9 inspection, you will receive a notice of inspection, either the mail or ICE can present it to you in person. Okay, that notice of inspection will list out what documents ICE needs you to present in order to conduct a audit of your Form I-9. Once that's issued, they'll take time to review it and inform you whether there is any documentation where they suspect the documents. The notice of suspect document is what is issued to an employer to inform the employer that the employer has accepted documents that the Immigration Customs Enforcement finds questionable, that they may be fraudulent documents. So you are then asked as an employer to go back to your employee and ask for different documentation to establish their employment eligibility or identity. There's a process of the I-9 audit. You have rights as part of the I-9 audit process too that I'm going to talk about. Then after they issue the notice of suspect documents and you address those issues, there could be a notice of discrepancies that is issued to you to inform you of any discrepancies that they've identified and ask you as the employer to correct it. So there is also a period of time where the notice of discrepancy, they provide you time to make corrections to the I-9 to avoid substantive violations. So if they find mistakes on your I-9s, for example, they will provide you with 10 business days to make corrections to the I-9s. And how do you make corrections? You can only make corrections if you kept copies of supporting documents, because it's not possible to make corrections because you forgot to put in a social security number, but you actually didn't make a copy of the social security card that was presented to you, but you know they presented it to you. But if you don't have a copy of it, there's no way for you to make that correction and avoid possible fines. Or let's say you accepted a driver's license and you forgot to date the expiration of the driver's license. If you don't have a copy of it, it's going to be a mistake that they can fine. It's an error that they can issue a fine on. But if you have a copy of it, you can make the corrections and avoid the fine. And that's why I take the position that I think that it's wise to make copies of supporting documents. I think that the belief is that when employers make copies of supporting documents, if an employee presented a fraudulent document and they make a copy of it, then they may be charged with accepting fraudulent documents. But that is very difficult. You are not considered to be a forensic expert as an employer. As an employer, you are only required to look at the documents and make sure that that document relates to the individual presenting it. And it's very difficult for the Immigration Service to bring charges that you knowingly accepted a fraudulent document. But that has been some of the concerns about making photocopies. But if there's no evidence that you had knowledge of whether a document is fraudulent or not, it's very hard for them to state otherwise. This is an example of what is issued when a notice of inspection is issued. They will provide you also with a subpoena requesting a whole list of documents, specific to your business. It can be copies of your quarterly income tax, your quarterly tax statements, a list of all subcontractors, federal contracts that you have, a list of the owners, agents or stakeholders or shareholders of the company. So in addition to requesting for copies of your I-9s, which you have to present within 3 business days, the Form I-9s, when you get a notice of inspection, you have to present it within 3 business days. In addition to those I-9s, they will issue this document asking for additional documents related to your business. You usually have the right to ask for an extension in presenting these documents. We ask for it all the time. We always ask for extensions because this can be a lot of information that you have to gather and collect, and they do usually extend a extension of the deadline to present these additional documents. But the I-9 forms really need to be in a state where you're ready to present it within 3 business days. That's how long they provide employers under the law to present the I-9s if you're targeted for an I-9 audit. So I-9 inspections, preparing for an I-9 inspection, we really recommend that you designate someone within your team or your company to be the I-9 administrator, the individual who oversees the I-9 policies, ensuring that one exists, making sure that you have legal counsel to help you with any internal audits or if there is an I-9 audit. We really recommend that companies conduct internal audits. Don't wait for ICE to conduct the I-9 audit. You as an employer can conduct an internal audit with advice and guidance from legal counsel or other individuals who have experience with I-9s to prepare for a potential I-9 audit by ICE. If you find that you are missing I-9s, as I shared previously, you definitely have the ability to provide new I-9s, meaning have the employer complete a new I-9 for you, and even if it's completed untimely. Okay. I-9 compliance, just some practice tips that I want to share with you in terms of if you are conducting a review of your I-9s to make sure they're all in order. Number 1, if you don't have an I-9 on file for someone, make sure you complete an I-9 for them. If you find mistakes on the I-9 and you want to make corrections, you can make corrections. Use a different color pen. You want your corrections to be transparent, meaning don't use whiteouts. Make it very clear that you're striking out mistakes that you've previously made and now you're making the corrections, and make sure you initial it per audit on January 1st, 2027, for example. Note when you make those corrections. So if you're subject to an I-9 audit, the investigator or the auditor will know that you made corrections after the I-9 was completed. Make sure you make the corrections clearly and never backdate I-9 corrections. Any corrections you make, as I mentioned, date it on the date that you make the corrections. Okay. And I've already talked about keeping copies of supporting documents and why. And it's really to help you avoid potential fines, because during an I-9 audit, if they find a mistake on the I-9, they can fine you for those mistakes based on the fines that I previously shared with you. How do you respond to I-9 notice of inspection? First thing is make sure you designate someone who's responsible for carrying out those activities at your place of employment. Contact legal counsel right away. We are very comfortable with responding to I-9 notices of inspections for any attorneys who is familiar with the procedure. They know exactly what to do, which is to reach out to ICE right away and and negotiate any kind of extensions for documents to be submitted and letting the government know that you have legal counsel. As I mentioned, employers have 3 business days to present the Form I-9. And please make copies of any communication email communication, document any oral communication that you engage in with ICE, with I-9 inspectors or auditors. Under ICE, there is what they call Homeland Security Investigation, HSI, and it is under that office that most of the I-9 investigators are based under the Homeland Security Investigation Office, HSI. So I welcome any questions regarding Form I-9. Now I'm going to discuss preparing for workplace investigations. How do you prepare for ICE and USCIS, Department of Labor, or other government entities? This here is just a workflow or a flow chart of how it may work. It's not always that way, but basically you will have a government agent visit your work site. We recommend you review the individual's business card and an identification to confirm that they are indeed a government officer or auditor and investigator. We did receive reports of people pretending to be ICE and other officers when this increase in immigration enforcement was starting. So make sure that you confirm whoever's appearing before you that they are who they are, okay? And you have the right to ask them about what is their purpose of the visit. And I'm going to share with you in that as an employer, you have the right to say you can't come into our business premise unless you have a judicial warrant. You have the right to say, I need to contact my lawyer to respond to your request. As an employer, as an individual, you do not have to allow ICE onto your premise or into your business unless they have a judicial warrant. And we get asked a lot, well, what does a judicial warrant look like versus an administrative warrant? And I will show that to you soon. But document your interaction with the agent. It is completely fine for you as an employer to state our procedure is to engage our legal counsel so they can communicate directly with you. We will be happy to take your information and share this with our legal counsel, and they will be in contact with you. Now, you may have situations where they push back, and that's fine, but that's why it's so important for you to practice this. We know that there's always a potential for I-9 audit or investigation, any government investigation. Do some role playing, practice, and stick to your policy that you've established. Of course, your priority is to make sure that your personal safety is the priority along with your employees, the safety of your employees or anyone around you, but you do have rights to ask for them to provide proof of who they are and the purpose of their visit. So you may have heard a lot about the fact that ICE really is an administrative agency, and it can't just come in and say, we want to talk to someone. You're not required to let them in. They really have to have a judicial warrant to really make you do anything. And this is what a judicial warrant looks like. It's usually issued by district court here. It is signed down there in the bottom right-hand corner by a judge, basically. This is what a judicial warrant looks like. Or a subpoena. It's signed by a judge down here, okay? This is what a administrative warrant looks like. It's issued by the Department of Homeland Security. It has the term warrant, but it isn't signed by a judge. It's signed by the Immigration Service or the immigration officer. And under the law, you do not have to follow an administrative warrant. I'm not saying to ignore it, but you can definitely buy time to say, let me contact my legal counsel so they can respond to your request. However, a judicial warrant, if they present it to you at your door, you really need to comply with it and follow what it states or is requesting. Okay. Other documents that you may see as part of any enforcement action is a deportation order. ICE may present a deportation order to you saying, hey, we're here to, we want to talk to one of your employees. We have a deportation order for them. Again, it's not required. You don't have to help them execute the deportation order. It's not a judicial warrant or a judicial order. You can ask them to take their activities outside of your place of employment, and or ask them for permission to contact your lawyer to get advice as to what you will do next. Administrative subpoena, again, compliance is not required. Judicial subpoena, it's required. You have to comply with it. You may challenge it in the future, but you must comply with it. Okay. So what are some of the other scenarios where ICE may come to you? ICE may contact employers for to obtain employee information. So essentially, if they're trying to execute a removal order, just be aware of privacy laws and industry-specific privacy laws that may apply to you depending on what your business is. You definitely have the right to contact legal counsel before releasing any information. Again, if it's not a judicial warrant, you don't have to take any immediate action. You definitely want to cooperate and say, I will, we thank you for this information. We will have counsel contact you, or our procedure is to have our lead HR representative respond to these requests, and we will be happy to respond to it, but I'm not in a position, or I'm not authorized to respond to the requests right now. Okay. ICE appearing at a work site to execute an administrative removal order. This is, as I mentioned, a common situation. Ask that ICE provide a copy of the subpoena and warrant so you can take a look at it and determine if it's an administrative warrant or a judicial warrant. You can ask ICE to wait for you in a private conference room and be transparent as to how you will contact the employee, or you can make the decision to say, our policy is not to engage in these activities if it is a personal situation related to one of our employees. We thank you for the information, but we ask that you take this and enforce it outside of our place of employment. You can have that conversation with them. It's just being prepared ahead of time. And of course, you can ask for a legal counsel to advise you as to what you need to do. So I know I've given a lot of information, and you're thinking, I just need to know the easiest thing that I have to do here to prepare. Number one, centralize the response. Designate one of your company representative liaison to be the point person for all government contacts or specific government contacts. If you have a team big enough, one person can be responsible for ICE responses, one person can be for Department of Labor, USCIS, but make sure your team members know who is responsible for responding to any kind of worksite enforcement activity. Communicate your plan not only to leadership, but to the people who are at the front line. Your administrative assistant or receptionist, they need to know what your policy is. So we have employers who will establish the policy, and the breakdown usually comes because it wasn't communicated to the individuals who really are on the front line and maybe getting that first phone call or that first visit through the door by ICE. And conduct trainings and drills with your team members so they know what to do. We know this is going to happen for the next couple of years here. No one should be surprised if they get a notice of inspection or if ICE comes looking for an individual that they believe may be employed with you. This is the time to prepare for it if you haven't already. Okay. So just a reminder as to what you should know in terms of your rights as an employer. And your employees do have the right to counsel before speaking to an agent and officer. You do not have to force them to do that without counsel. You have the right to inform your employees that they have the right to choose to speak to ICE or any government entities or investigators. You should not tell your employees not to speak to the investigator. It is their choice. You should not tell your employees to hide, leave the premise, or destroy evidence. If there's a work raid and you've confirmed it's a judicial warrant or subpoena that provides for that work raid, let it happen in the best way to keep everyone safe. Okay? So I provided a sample script as to what needs to be done. And if you are visited by ICE, and what I really want to emphasize to you is this: if you go through the I-9 process carefully and you have an I-9 on file for all of your employees, you should be prepared for the I-9 audit if it happens. There's a lot of confusion right now regarding who's authorized and who's not authorized to work. And I can have a whole different webinar on that issue. But USCIS is constantly updating their website. It may not be that good all the time, but they are constantly updating it for individuals, for example, who are were granted temporary protected status from countries such as Haiti, Ethiopia, Venezuela. As you may know, the current administration revoked the TPS status of those individuals, but there have been a lot of lawsuits that have been filed, and those individuals are allowed to remain in the US and are authorized to work while while proceedings are taking place. We had some decisions last week, for example, regarding Haiti, where the court stated that individuals from Haiti may remain in the US and their work authorization is extended until there is a final decision, similar to Ethiopia too. And so as the employer, please be very careful also not to take steps that may also violate national origin discrimination protection laws. There is also a sector of the Department of Justice, Immigrant and Employee Rights Section, who is responsible for carrying out provisions to protect employees from being discriminated or having their work authorization rejected unlawfully. So it is a difficult time because we see our current administration implementing and revoking work authorization for many different groups, but it doesn't mean that they're not authorized to work. And it's really important that you take action to confirm whether someone is authorized to work or not before you take any action that may make your business vulnerable to engaging in or violating anti-discrimination laws. Another big factor that we are seeing right now, especially in the Twin Cities, is the revetting of individuals who have been granted refugee status as part of the Paris program. Essentially, the administration stated that there's a group of individuals who were granted refugee status for during a certain period of time where their re-interviewing them to determine whether they have refugee status or not. If they have refugee status right now and they present to you a valid I-94 record to show their refugee status and it meets the list of acceptable documents, the I-9 of list of acceptable documents, it means they're authorized to work. Okay, so please, you know, when you are hiring individuals, if they can meet those I-9 requirements from the list of acceptable documents, you are authorized to hire them and complete a Form I-9. So I know the I-9 form, it's a one-page form that can be very complicated, but if you're able to fill out all that information correctly and follow the guidance provided, it means you're hiring someone who is authorized to work. If they provide you with a work authorization card that's valid, employers can still sponsor certain individuals for work authorization. I did not go into detail a lot about it, but the H-1B visa is a category where in September we heard about the restrictions for H-1B sponsorship. And thank goodness the administration came out with clearer guidance on it. But basically, employers can still file for individuals in H-1B status for work authorization. What it did was it established a $100,000 filing fee for employers who are sponsoring individuals who are outside of the U.S. for H-1B status. So individuals who are in the U.S. who may qualify to work in H-1B status, which is a work visa for individuals in specialty occupation. The H-1B is the most popular form of work visa that an employer can sponsor for foreign nationals if they're filling positions that are considered professional positions, a position that requires a bachelor's degree or equivalent. I'm going to stop now for questions, but I welcome any questions regarding the I-9 process or work eligibility issues or work visa issues. Holly, do we have any questions?
You sure do.
Great.
So I'll read them to you. The first one is when an employee is rehired, the previous I-9 can be used, but what if the driver's license is expired? Are we
Okay.
required to re-verify?
Okay, so the rule for I-9 maintenance is this, and this is very confusing. So I really recommend you read it in the I-9 central website. But an employer is required to keep a Form I-9 for someone that they terminated. So if you terminate an employee, you must keep their I-9 for at least 1 year from the date of termination or 3 years from the date of hire, whichever is later. Whichever is later. So for example, if someone's worked for you for less than 3 years, right? And they terminate their employment, you're going to keep their Form I-9 for at least 3 years from the date of hire. But if they've worked for you for 10 years and you terminate them, you only have to keep their I-9 for 1 year. Okay, so you maintain their I-9 for 1 year from the date of termination or 3 years from the date of hire, whatever date is latest. If you have an I-9 on file for someone who you rehire within those period where you still maintain their I-9, because really your best practice is to get rid of the I-9s you don't need to retain. But let's say you still have that I-9 on file. If their employment authorization is still valid, you only have to fill out the rehire date because you don't need to re-verify them. Their employment authorization is still valid. Their identity has not changed. So there's really nothing for you to fill out except the rehire date on the supplement B if their work authorization is still valid. Even if their driver's license has expired, that's fine because it's their work authorization that you're looking at. And these are for I-9s you've maintained. Does that answer the question? I hope so.
I think it does. And there's a second part to the question.
Uh-huh.
So, and this one's kind of asked in a few different ways. If if the rehire, like if the original form is an older version, do they have to fill out a new one? Or do they just use the older form and update the bottom with the rehire date?
Well, if you were required to keep the old form and it's still valid based on the rule I mentioned, you should just keep the old form because you didn't throw it away, basically. You did destroy it because it's part of the retention period. Now, if you make the decision to fill out a new Form I-9, you only have to fill out the supplement B part, which is to note the rehire date, right? So I see here there was from someone regarding H-2As and H-2Bs. I actually, our firm focuses on H-2As and H-2B. That is another type of work visa, but that is also employer sponsored, you know, meaning that you as the employer have to sponsor the H-2A or H-2B visa to hire someone to work under that visa. If someone comes to you with a H-2A visa, they're not authorized to work for you. You have to file your own H-2A visa and go through that process to hire them. Holly?
Okay. So the next one, I think I maybe even know the answer to just from listening to you. If a mistake is made while completing the I-9 by either you or the employee, is it best to fill out a new I-9 or can you correct the mistaken initial next to it?
You can correct the mistake and initial it if it's really a bad mistake and you want to just complete a new Form I-9. What you would need to do is go ahead and complete the new Form I-9, but attach it to the original document so they can see that what you did and that you timely filled out the Form I-9. Because remember, you can't backdate here on the I-9 form. Okay.
So you mentioned the list C, the social security card, let's say, the social security card says work authorization only. In that
Right.
case, should we ask specifically for the work authorization?
If they present a social security card to you that says work authorization notated, you would say, I'm sorry, this isn't an acceptable List C document. Can you present something else from the List C document or any other document from the list of acceptable document and let them choose?
Right.
Okay, you can give them examples. You know, I understand that, but don't tell them what to present.
When making copies of the documentation, do you need to make copies of the back side of the documentation as well?
You don't need to make the backside of the documentation.
Okay. This should be a quick one. Question on the issuing authority for List B driver's license. It says, is it state of North Dakota, ND, or North Dakota? Like which one is acceptable?
I would say any one of them. I could make a legal argument that you made the correct choice.
Yeah.
Of course, you want to write out as much as possible, but they should not be fining you because you wrote ND as the issuing authority here. You
Okay.
know,
So when storing the documentation, they're asking if you recommend just one file with all of the I-9s or if you put them only in each individual's employment file.
No, we recommend that you maintain all your I-9s together in one, whether it's electronic file or physical file. And the reason is if you're targeted for auditing or if they have a subpoena where they can go into your records, you don't want personnel records to be part of it. And it's easier for you to pull all your I-9s together when they're together instead of having to go to each individual's personnel file. So our advice has always been keep your I-9s together separate from your personnel files.
Okay, that's
Okay.
great. When conducting an internal audit and you notice that there are errors in the driver's license expiration and you don't have copies of the documents, how do
Can't
you
make
go
any,
about avoiding fines for these
you, c-
instances?
you can't make corrections to it. I mean, if you notice that you forgot to write the expiration date, you could ask your employee to come in and, you know, say, hey, we made a mistake. Can you present this again? But if it's years later, they may not have it. And that's why I'm a big fan of making copies.
Make copies. If a new hire fills out the I-9 on an older expired form, do you need them to recomplete it on a current form?
If it was if you conduct an audit and realize that you used the wrong form, again, you can have it on a new form or the correct form, but attach it to each other and make a memo as to why you now have two documents.
Okay. And then, is there any downside to fully cooperating with ICE, even if it is not mandatory?
No, there isn't any downside. It's up to you as to, and we're not saying not to cooperate. Please know that. It is about what rights you and your employees have. And I can share with you, being here with what has happened in the Twin Cities, that we've seen some really aggressive action. I've worked for 30 years with ICE. I know these investigators here in Minnesota. They're good people. I mean, I would never say not cooperate. It's just, what are they asking you for here? And you have rights as an employer not to present information that you're not required to present. And that's all we're advising, is just to know your rights. I see here a question or a statement that certain companies require the front and back of state IDs, social security cards, and EADs. All employers are required to, unless they're engaging in the remote inspection process, they are required to look at the actual document of the documents you present. If they're doing remote inspection, they're required to look at it through video conferencing. So it just depends. I don't know if there are certain companies that they can make copies of the front and back, but you should not be presenting copies to them. You're supposed to present originals to the companies, and the companies are responsible for making copies.
Okay, the next question is an interesting one. Every time we submit an I-9 with a work authorization category C11, they receive a TNC. Is there more documentation we can submit for them to be able to work, or are they not able to work until they apply for a different work authorization card or green card? Different category. What's a TNC?
And tentative non-confirmation. And
Mhm.
C11 is a EAD. I mean, there's a whole list of codes, you all. So I don't have it memorized. So if anyone wants to put in, I can look it up really quickly what C11 is. But that's a specific question. I'll be happy to answer it. That if you receive a tentative non-confirmation on something and it doesn't make sense to you, call E-Verify and ask. That's when you're using E-Verify and you have a
I think it's
representative.
I think it's pending asylum, but I'd have to look it up
Yeah,
too.
but like I said, if it's C11 and it's a valid document, they're authorized to work. And if you're getting a tentative non-confirmation, it doesn't make sense.
Okay.
And so you need to call your representative. C11 is pro. So basically it's TPS from certain countries, or pro from certain countries is what someone has typed in. But again, if it's a valid work authorization card, and it hasn't been revoked, it should go through E-Verify. So I would recommend you contact your representative at E-Verify and find out, what do you need to do here. If they meet the I-9 requirements, they meet the I-9 requirements.
So there's like continuously more and more questions.
Yes, I
Here's
love it.
the next one is, when a person is hired and their work authorization form expires, is there a certain grace period that they have? No. Okay.
Really, under the I-9 rule, you're supposed to conduct re-verification before it expires. Now, ICE did come out with a memo years ago, before the current administration, saying that you should provide them with reasonable time to provide the information. But reasonable time is open to interpretation based on the administration involved. And really, if they cannot establish employment eligibility or provide you with documentation for re-verification, you need to seriously consider what the pros and cons are if you continue to employ them. And it's a business decision as to how long you give them.
What are the rules guiding the use of E-Verify? Specifically, if an organization completed paper I-9s in the past and recently transitioned to
Yeah.
E-Verify.
You cannot go back and e-verify those individuals who you hired prior to the signing of the memorandum of understanding, except if you are a federal contractor, there's exceptions to that rule. But a an employer who signs up for e-verify, you can't use e-verify to audit your I-9s previously to signing up for e-verify. It is not an auditing tool here. So please don't
Okay.
use it as that.
Do you have to fill out the rehire section for employees that come back to work after being laid off for a couple of months?
Not if you retain their I-9s, right? The retention period that I shared with you, if you still have
Yep.
their I-9s and it's still valid, you just note the rehire date.
And I think you kind of got to this one earlier. It says if an EB3 has been started, can an H2B be done to get the applicant here earlier than waiting? Does the
I did
I-9
talk,
pertain to both of
yeah,
these?
I did talk about that, and that's
Yep.
a very specific question, which I do know. So, the H2 modernization rule was passed about 2 years ago, and it stated that an individual who has a green card process started for them, such as a EB3 immigrant petition, that in itself does not make them ineligible for their H2 visa or H2A visa that they apply, because H2Bs and H2As have to have non-immigrant intent. It's a temporary work visa. So the best practice is if you're filing an immigrant petition for those workers, note that they're going to consular process and that they're not going to seek adjustment of status. You can absolutely have them change their mind afterwards, but you can file an immigrant petition for a H2B or H2A worker, and they will be asked that question, but we have some breathing room because of the H2 modernization rule, so I recommend you take a look at that rule.
Okay. I know we're at time, so are you okay to answer a few more questions?
Sure, I am. Let me
Okay.
just
So section
go
1,
ahead.
the employer section, do you have to fill out all the boxes?
The employer or employee section.
Oh, it says employee section.
So the employee should fill out the information needed, but if they don't want to provide a phone number, they don't have to provide a phone number here. If they
Okay.
don't have a social security number, they don't have to fill out the social security number if they don't have it. Now, as I mentioned, the E-Verify employer will need it to run someone through E-Verify, but if they don't have it at that time, they can request additional time to get the social security number to them.
Okay, here's another one. If they present an employment authorization card, should you fill in the IOE or USCIS number for the document number in section 2?
Um, in regards to the IO number is the receipt number that you have. So you should definitely fill that out, but I would reference you to the I-9 Central website, and it has examples of what you need to fill out. If you're ever under, you know, a situation where you don't know what to fill out, just make a copy of the form or the card and attach it, but fill in as much of the information as possible on the form. Yeah, that is the receipt number. You should put that down on the section A when someone presents the EAD card.
And so there's a lot of questions about rehiring. One in particular, it says all rehire employees need to complete the re-verification and rehire form.
So what, I'm sorry, what is the question again?
It's just says, please verify all rehire employees need to complete the re-verification and rehire form.
So re-verification, okay, supplement B is the section for re-verification or rehires. It's just that one section, supplement B. So you can note, rehire date and fill it out, or you can just note the rehire date if the work authorization is still valid. You note it in supplement B.
Yeah, and there's like the next question I'm looking at is related to that too, right? So you note it in supplement B. You don't need to do a new form.
You can if you want to, but you don't need to.
And then another thing we talked about the C11. Megan Carranza noted that the category is parole.
Parole, right? I saw that.
Yep.
Again, parole has been terminated for many individuals,
Mhm.
and in regards to if it's a work authorization that's valid, it's a valid work authorization card.
Okay. So, okay, I don't know if you've answered this one yet or not, but it says, I was told once that for section 1 to ask employee to enter NA instead of leaving it blank.
Yeah.
Is that a thing? Or
That,
could
yeah,
they just, okay,
that's good. So if it's audited, they know that they purposely did not fill it out. If you write NA, it's not applicable. If you leave it blank, they don't know if maybe you forgot it and you may have that information. So it's good
okay.
to know NA.
There's another question here. Maybe you just want to repeat it, but it's about, do we keep the I-9s together or in the personnel folder?
Please keep your I-9s together and not part of the personnel files, meaning don't, keep all your I-9s in one area, electronically or physically, and their supporting documents if you make copies of supporting documents. Do not put it in their personnel file with other information that you do not want ICE to have access to.
And then this is a good question too. This is the last one. If you previously told your employees which documents they needed to submit in order to fill out section 2, do you need to fill out a new I-9 for them?
No, you already did it. You already filled out the form I-9. You already told them what to fill out. It's already done. There's no reason to complete a new I-9 to correct what you previously did. Just don't do it again.
And I don't know if this one is for you, but it says if someone loses their work permit or social security card, is there a way to get a new one?
Absolutely.
Yeah.
Yes, absolutely. You can file for a replacement card. The I-90 form is to put for the Immigration Service, and Social Security Administration has its own process and documents to get a new Social Security card.
So if there's any questions that I missed, maybe if somebody just wants to pop off of mute and ask them, you're more than welcome to do that.
Well, thank you so much for having me here, Holly. I hope it was helpful. It's definitely fun answering the question.
I think you may have one person who wants to ask a question before
Okay.
TJ? Maybe not. It looked like he was coming off of mute. But no, thank you. This was so incredibly informative, and I really appreciate you staying on extra to answer all these questions because, there's clearly a lot of questions and a lot of interest in this topic. So we're just so grateful to you for making some time this afternoon.
As I mentioned, I'm based here in Minnesota, but we have an office in North Dakota. So North Dakota, we have a couple of offices in Bismarck and Fargo, and so we work all across the upper Midwest and across the US. So if you have any questions, let us know. And thank you so much for your engagement. And Holly, thank you so much for having us here.
You have one more question.
Okay. Is it Lori?
Yes. Hi, Lone. My name is Lori. And I just have a question. If you have a new hire fill out their I-9 in front of a notary public, would you need to have copies of the documentation?
It's up to you as to what your policy is. The notary has been authorized by you to fill out the form, and whatever your company policy is in regards to I-9 procedures, that's what you should follow. The notary is really your representative.
Yep.
Yep.
Okay. All
So
right.
just
Thank
follow
you.
your normal procedure. Yes.
Thank you.
Welcome.
And this is kind of a good question too. Why would it matter if ICE had access to any of the employees' information?
You don't want ICE to go into if you're a physician office, for example. I mean, think about all the privacy data you have that needs to be protected under HIPAA. ICE doesn't have a warrant, a judicial warrant usually. If it was a judicial warrant asking for your personnel files, that's different, but you want to keep your I-9 separate from your personnel files. If you're audited and within your personnel files or all your payroll records for this individual, what if they start looking as to whether you're really paying your employees what you're really required to pay under the law? You just don't want to provide more information than it needs. If it comes in and is conducting an I-9 audit and it only wants I-9 forms, that's all you need to give to them under the law. You're required to give them your I-9 forms within 3 business days, or if they have a warrant for that day, then you're going to have to give it to them, or they go into your records to pull it out. You just don't want them to have access to documents that they don't need.
That makes a lot of sense. And I think we maybe have one final question from Bridget Hill, and she's got her hand raised.
Hi, I have a question. So on I-94s, they have a little expiration date. It's an OMB and then have an expiration date. And employers, if you show them the I-94 as a, valid document, they think that it's already expired.
Well, the I-94 record will show entry date valid until whatever date that is. So I'm not sure what so it does expire if there's an expiration date. There is an expiration date on the I-94 document in terms of what someone's lawful status is in the US. So for example, if you enter the US in H-2B status, it's going to say admitted on this date, val until this date. And if that until date has passed, that means they shouldn't be in the US unless they have another document. I'm not quite sure what other date you're referring to. I'd be happy to take a look at it, but the I-94 record, unless you're a student or a J1, will have a specific end date.
Okay. Yeah, it was just the office management and budget approval is a period for the U.S. Customs and Border Protection form for the I-94 is for arrival and departure record only, nothing to do with employment. So
actually, it is related to employment. Also, an individual may come in and only have their passport and their I-94 record to establish their employment eligibility and their immigration status in the US.
okay. Sounds
That
good.
I-94 record is really important. So let's say you have an H-1B worker, right?
Mhm.
Or a H-2A worker. When they enter the US, they will have their valid passport and maybe their H-2B or H-2A visa stamp. But what gives them work authorization and legal status in the US is that I-94 record. If they don't have it, you can't fill out your Form I-9.
Right. I
Right?
just didn't know why that little stamp on the bottom was there.
Yeah, no, I'm
I
not
didn't
quite sure what stamp you're referring to, but there is a validity date on the I-94 record. And it's
Okay.
in my presentation, I think I showed you.
Okay. Yeah, it's called the OMB expiration date.
Okay,
So
the OMB is the Office of Management and Budget, and
yeah.
that's the issuing entity in terms of when that I-94 template is going to expire, but that information is different. The OMB is just the addition of the I-94. Does that make
Okay.
sense?
Right. When if an employer sees that, then they think that their I-94 has expired.
That doesn't make sense. No, the I-94 record should really be clear in regards to, let me show you. Let's see here. I don't know if I have a copy of here. I'll be happy to share my screen again. Let's see if this works, okay? So here you are. This is a I-94 record, electronic one. Do you see?
Mhm. Yes.
Admission, admitted until. That's the date.
Right.
Okay. So that's what matters. If there's some kind of OMB number down here, like this is another I-94 record too. You know,
Mhm.
this here, that has nothing to do with their status. I think this is what you're talking about, the OMB right here.
Right. Yep. And
That,
employers are
but what
taking that differently.
well, that's wrong because
Or-
they need to
Right.
look at this. They need to look at this here.
Right.
Okay.
Perfect. Thank you so much. I appreciate
Welcome.
you.
Oh, thank you.
It looks like that's all the questions, but just
All
a lot
right.
of people, thanking
Yeah.
you for sharing all this great
Oh, thank
information.
you.
Um,
Appreciate you all.
Job Service will have this recording available, and if they want the slides, I put the email. It's just refugeeservices@nd.gov.
It's great.
If you want to just put I-9 in the subject line, we'll be happy to share the slides. So thank you so much for participating, and Lon, you're really appreciate your time.
Thank you. Hey, Holly, I'm going to send you a new version. Can you hold off on posting
Sure.
or okay, thank you.
All right, sounds
Bye.
good. Thanks a lot.
Bye-bye.
Bye.